My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Today I want to talk about alimony from the standpoint of non-payment and the mounting debt. We get calls like this a lot where people will say to us, look, I owe alimony. I haven't paid alimony in a long time. I owe $10,000. You owe $10,000? Yeah, a year. What do you mean a year? Well, I haven't paid it in 8 years. We'll get that kind of thing. So now it's not $10,000, they owe $80,000. So what happens with that? Putting aside the fact that the court can charge you with a crime for non-payment of appropriately ordered support item, putting that aside momentarily, what you've got is a situation where you've got to figure out, what am I going to do about all this money that I owe? How am I going to address that issue? And there's a couple ways to do it. Number one, if you owe a lot of alimony and you have a good relationship with the person who is supposed to get the money, you might be able to work out something with them. You might be able to enter into an order discharging the alimony debt, or you might be able to say, look, I owe you $80,000, I'm in position to borrow $20,000. You haven't been paid for years anyway. Would you accept the $20,000 and waive the rest? Believe it or not, sometimes people do that. They'd rather get something rather than nothing. So that's a possibility. In other words, you may be able to bargain it away. If you owe thousands, though, you got to remember one thing. It's not the kind of thing where you can necessarily file a motion and get a prior debt discharged. If something happened and you couldn't pay it, you would have been in a position to file a motion to ask that it be suspended from that point forward. But if you already owe the money and you've done nothing about it, the court can't enter an order that says, yeah, I know you owe her money, but I'm going to enter an order nullifying it. The court's not going to do that. The court doesn't have a right to tell somebody to whom money is owed, you're not getting it. And that's not what the court is for. Now, the court may say, instead of paying $1,500 a month, you have a change in circumstance, you still owe $80,000, but I'm going to let you cut it down to $500. I'm going to let it cut down to something else until you can get further on your feet, or maybe you'll get a big tax refund or something like that. I mean, the court has the ability to do that, work within it. But remember, since it's owed to somebody else, the court can't nullify it. So therefore, the best thing you can do is try to create either an agreement with the person directly, or if that won't work, try to get the court to allow you to go into some sort of payment plan. If you do nothing, the debt will mount. You risk being charged with a criminal offense, or at the very least a show cause for non-payment under the court order, and it's going to get very nasty very quickly. The best thing is, if you find yourself in a position where you've missed an alimony payment and that's because you can't afford it and it looks like you're going to miss another one, at that point in time, you should be hiring a lawyer to file a petition to modify the support downward so that you won't have some huge mounting debt that you'll never be able to pay. If you have any questions about that, reach out and we'll be glad to help you out.